Scales # buckle up, because what you're about to witness isn't your average courtroom case. This is the story of Mr. Martinez, a man found alone in an apartment with 5 adults locked in a bedroom, no cell phones, plywood on the windows, and nearly $12,000 in cash. The charge: operating a stash house, a term usually reserved for high-level trafficking operations. But here's the twist: Martinez claims he doesn't even know the people who were locked inside. Flushed face. From bizarre denials to intense back-and-forths over legal definitions, this courtroom battle dives deep into what constitutes control over a property, and whether ignorance is enough to escape a serious felony charge. We'll break it all down: the wild testimony, the cash-filled envelopes, and a judge who's not holding back. Is Mr. Martinez a scapegoat, or a player caught red-handed? Stick around. You won't believe how this plays out. Let's dive in.
All right. So, Mr. Martinez, you were charged with operation of a stash house. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will.
Let's pause here. The officer finds 5 adults locked in a single bedroom, with no cell phones, only 3 pillows, and plywood covering the window. That's not just suspicious, that's straight out of a trafficking horror story. And yet, Martinez claims he had no idea who these people were. Here's a legal nugget for you: under Texas law, what matters isn't always ownership, it's control. If you're the only free person in an apartment where people are being held, prosecutors can absolutely argue that you had effective control over the space. But the question remains: is ignorance a valid defense, or just an excuse?
Will be appointed to you, sir.
Yes, Judge. On November 24th, 2024, officers were dispatched to an apartment in Harris County, Texas. The officer located 5 adult complainants locked in a bedroom while conducting a welfare check. The officer observed the defendant to be the sole person in the apartment that was not locked in the bedroom. The officer determined the apartment to be under the control of the defendant. All complainants gave similar statements and stated they were held in the locked bedroom without the ability to come and go freely. The complainants were all found to be in possession of identifying documents, but their cell phones had been taken away. The complainants stated if they needed to leave the bedroom, they had to knock on the door and be led through the apartment, sometimes with a bag over their head, by one of 2 males in charge. The defendant stated he lived at a location with another male, but that he did not know the other male very well. The defendant denied knowing the 5 people in the apartment. Instead, they were dropped off in the morning that day, but he did not know who dropped them off. The defendant was found with $5,959 on his person, and the officer further observed the door where the complainants were being held was only locked and unlocked from outside. The room was bare of any furniture, no mattresses were in the room, only 3 pillows and multiple blankets, and a large sheet of plywood covering the window. The officer also found the room had no working light bulbs. The officer observed a desk in the dining area with 4 envelopes with his name and $3,600 written on them, containing cash, a total of $11,200.
Did you catch that subtle moment? The judge doesn't just move on, he says, "I'm going through this with a fine-tooth comb." That's not just formality. It signals that something about this case doesn't sit right. Judges handle dozens of cases a day, but when one makes them stop, recheck the code, and consult colleagues, you know it's serious. And notice how they are struggling to categorize this. Even veteran officials are digging through statutes. That tells you how unusual and legally murky this case really is.
So I was going to do a deeper dive on it to see whether there's probable cause. It's the first time I've seen something like this.
Yeah, same here, Judge.
Do you mind do you have somewhere else to go?
I do.
Can you go do that and just come back maybe
Yes,
in
sir.
like an hour? Let me blow through all the arraignments and then
No
we'll
problem.
sit.
I'm gonna just let my client know and I'll be right back.
Yeah, I mean, I want to open the code. Let's go through it and take time, you know? Yeah, okay, sure.
Translator.
Ready? Hey, Morgan. So I'd like to do PC on this case. This is that stash house.
Yes, we're actually talking to Nathan about that right now.
Nathan,
Yes, sir.
this is a very, it's a first for me,
Okay.
a stash house.
Yeah,
Have you seen this before?
I have, but not for a long time.
And I gotta understand,
I'm looking it up right now.
why is it's not higher up? It's
No,
not most like
most staff houses
feds?
are misdemeanors. It's strange. Most staff houses are. I teach at the police academy.
When the district attorney says, "I teach this at the police academy," you know he's not taking this lightly. This isn't just a one-off incident, it's textbook, and potentially dangerous. Stash houses are usually linked to organized crime, human trafficking, smuggling, you name it. And the fact that the prosecutor is referencing educational level knowledge means he's framing this case to show patterns, not just circumstances. But what do you think? Is it fair to judge Martinez by the environment he was found in, even if he claims it wasn't his doing?
Mr. Martinez, come on up. Okay. Shh. All right, Mr. Martinez, you were charged with operating a stash house. I wanted to make sure that your lawyer was here when we did probable cause. You have the right to remain silent. Anything you say can or will be used against you. Here we go.
Yes, sir. On November 24th, 2024, the officer was dispatched to an apartment in Harris County, Texas. The officer located 5 adult complainants locked in bedroom while conducting welfare check. The officer observed the defendant to be the sole person in the apartment, not locked in the bedroom. The officer determined the apartment to be under the control of the defendant, and all complainants gave similar statements and stated they were held in the locked bedroom without the ability to come and go freely. The complainants were all found to be in possession of identifying documents, but cell phones had been taken away. The complainants stated if they needed to leave the
This is where things get chilling. The complainants say they had to knock just to leave the room, and were sometimes led out with bags over their heads. That's psychological manipulation, and it screams coercion or control. Whether or not Martinez did the blindfolding himself, being the only person not locked in the apartment raises serious flags. At best, he's willfully blind. At worst, he's an active participant. Let's put this to you. If you were living in a home where this was happening under your nose, wouldn't you know something was wrong?
bedroom, they had to knock on the door and be led through the apartment, sometimes with a bag over their head, by one of 2 males in charge. The defendant stated he lives at the location with another male, but does not know the other male very well.
Okay, whoa. So the defendant says that he lives
At that location.
at the location,
But he does not know the second male that also lives at the location.
doesn't know him well, or
Doesn't
doesn't,
know well.
okay,
Yes.
all right.
Yes. And the defendant denied knowing the 5 people in the apartment. Instead, they were dropped off in the morning, and that he did not know who dropped them off. The defendant was found with approximately $6,000 on his person, and the officer observed the door where the complainants were to be unable to be locked or unlocked from the inside, only able to be locked from the outside. The room where the complainants were found was free of any furniture, with no mattresses on the floor, and only 3 pillows and multiple blankets. Officers also found a large sheet of plywood covering the window and no working light bulbs. The officer observed a desk in the dining area with 4 envelopes with names in 3,600 written on them containing cash, a total of 11,200. Officers also found a brown wooden baseball bat on the desk with the envelopes.
If I may, Your Honor. So my understanding is that the, I guess the code says that he has to own the property or rent it. But he was actually renting a room from the guy that lived at that apartment. So he had only paid 1 month of rent to the guy and was going on his.
Here's the defense strategy. Martinez was just a room renter, not the leaseholder, and didn't know what was happening. That may sound plausible, until you remember he was found alone, with $6,000 in cash on him, and $11,000 more stashed in envelopes marked with names. That's a lot of money for someone who supposedly just woke up and found strangers locked in the house. Also, let's not ignore the wooden bat on the table, an intimidation tool, perhaps. The defense is leaning on plausible deniability. But does that hold up against physical evidence?
Vehicle, boat, or other property owned by the person or under the person's control to commit an offense or to facilitate the commission of an offense under.
Which is, Judge, those other sections are smuggling or trafficking.
Right. Or rents or leases any property to another, intending that the property be used as subdivision 1.
Which would be him allowing them to use the property for such commission of alleged offense, but it wasn't his. I guess my issue is that it wasn't his property. He was not on the renting order.
And Your Honor, the officers found him to be under the property to be under his control, as they found him to be the only person on the premises at that time, not locked in the bedroom. So yeah, that's why it was the officer's conclusion that he was in control of the property at the time.
What evidence do we, Nathan?
Yes.
What evidence do we have that he knows the persons are being trafficked or being held?
Well, in these cases, typically, Judge, somebody's not going to come out and say, I know everybody's being trafficked in this room. It's going to be a matter of circumstances, the totality of the circumstances, I would say, to make that out. And I believe, Judge, based upon the information that we have, that we're at least.
This part is crucial. The defense says the complainants described 2 different men, one older, with a gray beard. But Martinez was clean-shaven at the time of arrest. So, does that clear him? Not necessarily. Eyewitness testimony can be unreliable, and changes in appearance, like shaving a beard, could happen after the crime. What the judge is doing here is pressing both sides to determine whether there's reasonable doubt. It's a small detail, but one that could make or break a felony trafficking charge.
The complainant won't describe the.
So hold on a second, because are you telling me that the people who are held captive are saying that it's another 2 people who are acting?
There was, Your Honor, there was a description giving older with gray hair, a round face, and a beard, and the officer observed the description given to fit the physical description of the defendant. So there was a description given by the complainant, and the officer observed it to match the defendant.
Well, but the time he got arrested, he didn't have a beard. So because the mugshot doesn't show a beard, so I would assume. I mean, I would have to see what they said. I just don't think it's.
I think he's there. He's alone. There's $11,000. I mean.
The other thing too is, Judge, it's my understanding based upon ADA Farmer's recent, I guess, knowledge of the statute that is modified to felonies in some cases, which we may be refining this case as a felony. I always try to warn, I'll just say less experienced defense attorneys when you're doing it, and ultimately all this cost argument, sometimes it comes back worse when you go to felonies, which I think may happen at that pace, that last criminal initiative is early.
Be careful what you wish for.
Now this is a legal curveball. The charge was initially filed as a Class A misdemeanor, but it turns out the law was updated. It's now a third-degree felony. That's a major escalation. Third-degree felonies in Texas can carry up to 10 years in prison. It's not just about holding people accountable, it's about understanding how fast laws evolve. This could affect hundreds of similar cases in the state. Question for the comments: should the court stick with the original lesser charge, or immediately upgrade based on the new law?
Oh, yeah. Yeah, look at that. Year 2026. All right, so, Mr. Martinez, I am going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to engage in this behavior, not to be in possession of any weapons. If you pick up a new case, if I find you with a weapon, if you engage in this type of behavior, I will put you in jail. I will not give you any more PR bonds. I don't know what your status in this country is, but if you're in this country without permission and you go to jail and immigration finds you while you are in custody, they will put an immigration detainer on you, and you will be stuck in custody until the case is over with and then shipped off to immigration. You are on notice now that I'm going to do everything in my power to protect my county. I don't care who, what, when, where, but if I find that you're a public danger, then I will put you in custody. Do you understand? You have a lawyer. It is your responsibility to stay in touch with counsel, and they will tell you when you have to come back to court. If they tell me that they are unable to reach you because you're not responding to phone calls, text messages, likewise, I will issue a warrant for your arrest. No more PR bonds for you, sir. So we'll just have him sign the bond conditions, and then he's free to go with you.
Thank you, Judge.
Yes, ma'am. And so for what it's worth, it is now a third-degree felony.
In the end, the judge found probable cause to move forward. Mr. Martinez walked out of the courtroom that day, but with serious restrictions, including a ban on returning to the stash house and strict bond conditions. Whether he was an unwitting bystander or a complicit participant is something a jury may soon decide. But one thing's for sure, the justice system isn't taking stash houses lightly anymore, especially under updated state laws.